Okay, so we've all heard the term breach of duty thrown around, right? Especially in those courtroom dramas. But what does it actually mean when the lawyers get involved? Let's get past all that TV jargon and figure out what's really going on.
So, when we talk about being legally negligent, what does that really mean? What kind of failure is the law actually looking for? It's a super common point of confusion, but don't worry, we're about to make it crystal clear. I find the best way to really get your head around a complex idea is to first clear away all the clutter. So, before we can define what a breach of duty is, we've got to talk about what it isn't. Seriously, busting these common myths is the first and maybe most important step to getting this right. All right, this first one is a big one. It feels totally natural to think that, hey, if someone's actions made you feel really emotionally distressed, there must have been some kind of legal breach, right? It just seems logical. Well, let's see what the actual source material has to say about that.
And there we have it, our first myth. Now look, it's totally incorrect, and here's why. While emotional upset is absolutely real and valid, the law of negligence isn't focused on feelings. It's laser focused on a person's conduct, their actions. It's all about what you did, not how somebody else felt about what you did.
Okay, let's tackle the next set of myths, because this is where different areas of civil law get super tangled up. A lot of people think a breach of duty is the same thing as, say, breaking a promise or not holding up your end of a bargain. But that's a whole different legal universe altogether. And you can see the core difference laid out right here. On one side, you've got tort law. That's where negligence lives. It's all about this general duty we all have in society not to carelessly harm other people. But then you've got contract law. That's about very specific duties you voluntarily create by making an agreement. The standards for each? Yeah, they're completely different. So here's our first contract-related myth, and this comes straight from the source. Delaying something you promised to do in a contract? Look, that's definitely a problem, for sure. But it's a breach of contract, not a breach of duty. The duty you broke was the one you signed up for in that specific deal, not that general duty of care you owe to everyone in society.
And here's the second one, same idea. Outright refusing to do what you promised in a contract, that's the textbook example of a breach of contract. So again, it's absolutely a legal issue, but it's just not a breach of duty in the world of negligence. We've really got to keep these two lanes separate in our minds.
Okay, let's recap. It's not about hurt feelings. It's not about broken promises or contracts. We have now officially established what a breach of duty is not. So, what is it then? Let's finally pull back the curtain and reveal the correct answer. And there it is. That's the one. A breach of duty happens when a person simply does not do what a reasonable person would have done in the exact same circumstances. It's not about being perfect, not at all. It's about being reasonably careful. This concept is the absolute bedrock of negligence law. But, of course, that just leads to the next big question. Who in the world is this reasonable person? So the reasonable person isn't an actual person. It's not you, it's not me, it's not the judge. It's a totally hypothetical legal standard. You can kind of think of it as an invention of the law, this imaginary, careful, prudent, and conscientious person that we can use as an objective measuring stick to judge someone's actions in just about any situation. So how does this actually get used in a courtroom? Well, it's a surprisingly logical three-step process. Step 1, you figure out the specific circumstances of what happened. Step 2, you determine what our imaginary reasonable person would have done in that situation. And then step 3, you compare what the defendant actually did to that standard. Like, think about it. If a grocery store owner sees a spill, a reasonable owner would put up a wet floor sign, right? If they don't and someone slips and falls, their failure to act is compared to that standard. Their conduct fell short. And boom, that's the breach. And listen, if you take one thing away from this, let it be this. It's an objective test, not a subjective one. It doesn't matter if the person genuinely thought they were being careful. It doesn't matter if they meant well. The law doesn't care what was going on in their head. The only question is, did their actions, their conduct, meet the external, objective standard of a reasonable person? That's it. And this is exactly why this standard is so important to our legal system. It's all about ensuring fairness and predictability. It gives us a benchmark that's based on actions, not emotions. It's an objective test, not a personal one. It keeps things totally separate from contract law. It creates a single, predictable, and fair legal benchmark for every single one of us. So, let's end with this thought. This whole reasonable person thing, it isn't just some abstract legal idea for lawyers to argue about.
It's actually a pretty practical guide for how we all navigate the world and our responsibilities to each other. So just for a second, think about it. In all the things you're going to do today, how would a reasonable person act in your shoes? It's kind of a fascinating question to ask yourself, isn't it? Thanks so much for joining me.